you huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
Right out of the gate, Judge Simpson sets the tone, and it is crystal clear. This isn't a casual docket call. This is a courtroom where patience is thin and expectations are high. We're dealing with Samuel Peoples, a defendant now facing multiple issues, including a bond violation tied to a Tether tampering charge. That alone raises eyebrows. When someone is on GPS monitoring and cuts the tether, that's not a technical glitch. That's a direct challenge to the court's authority. But here's where this case gets layered. The defense immediately requests a forensic examination, signaling potential competency concerns. That changes the temperature of the room. A competency evaluation means the court must determine whether Mr. Peoples can understand the proceedings and assist in his own defense. That's foundational to due process. So now we have two parallel tracks, a felony case and questions about mental fitness. Add in a bond violation and the stakes rise fast. Is this defiance? Is this crisis? Or is this a system trying to respond to both accountability and mental health? Stay with this, because what happens next reveals how much discretion a judge really has.
The court does call the cases of the people versus Samuel Peoples.
Thank you, Richard. People.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, in file 1326, Mr. Peoples has not yet been referred to the forensic center. I've prepared an order, and we are asking the court to order a forensic examination. In that case,
All right, I will order a forensic examination without objection. On that case, what is my next date? Let's see how. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just last week.
That was last week. All right. So set a competency here, October 2025, 9 a.m. All right. What are we doing on the other case?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326.
Well, also arose with Tether.
Which is charged as a felony, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
Let's break this down. A tether tampering charge is serious. In many jurisdictions, cutting or interfering with a GPS monitoring device is treated as a felony because it suggests risk of flight or disregard for court supervision. Even if the defendant doesn't leave the area, the act itself undermines the condition of release. But here's the twist. Everyone acknowledges he didn't actually go anywhere. He cut the tether, but stayed put. That complicates the narrative. Was it an attempt to flee? Or was it, as he later claims, an anxiety-driven reaction? From a legal standpoint, the court has to evaluate risk. Bond conditions exist to ensure public safety and court appearance. If a defendant tampers with supervision equipment, judges often revoke bond entirely. So here's the question. If someone violates a bond condition but doesn't attempt to escape, should that distinction matter? Is intent more important than action? This moment is where discretion starts to shape the outcome.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's specific.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I had a lot of anxiety.
Response?
Your Honor, obviously we had an extended conversation about this at bench, at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that, given that we have this incident, I don't know how sufficient that's going to be, but I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're going to cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before you just did it?
I had a moment of anxiety that led to a freak out. Yes.
This is a pivotal emotional moment. Samuel admits to cutting the tether, but frames it as a claustrophobic panic response. And Judge Simpson's reaction is telling. He acknowledges it, but he doesn't excuse it. You understood it before. You just did it. That's accountability language. Legally speaking, mental health struggles do not automatically erase responsibility for violating bond conditions. However, they absolutely factor into how a court evaluates risk and future compliance. The judge is weighing two things simultaneously: public safety and the defendant's capacity. Notice how the tone shifts here. It's less adversarial, more evaluative. The judge is probing. Can this person comply going forward? Can he trust this promise? And think about this. How often does a courtroom become a place where mental health crises intersect with criminal procedure? Should the system lean more toward punishment or stabilization in moments like this?
And I felt like I needed to get it off me because it was claustrophobic. And
Got it.
yes.
I hear you. Okay. All right. Here's going to be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap. Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
All right. Samuel,
Yes, Your Honor.
I give you another shot. You're going to try to do the right thing?
Yes.
Okay.
Thank you, Your Honor.
All right. I'm going to do it. I think you can do it.
You too.
Okay.
All right.
Got it?
Thank you.
So what's going to happen is somebody's going to have to pay money for the strap that got damaged.
Here's the practical consequence. The tether strap was damaged, and someone has to pay for it. That $175 fee isn't just administrative. It represents restitution for the cost of supervision equipment. Judges often condition release on repairing financial harm caused by violations. It reinforces responsibility. You break it, you fix it. But notice something important. Instead of escalating the situation, Judge Simpson reinstates the previous bond. That's significant. He could have revoked bond entirely and held Samuel in custody pending competency proceedings. Instead, he gives him another shot. This is judicial discretion in action. The judge balances the violation against the context. Mental health concerns, family involvement, and the fact that Samuel didn't flee. Would every judge make this call? Probably not. Some courts operate with zero tolerance on tether violations. This decision signals cautious trust, but it's conditional.
On your tether.
Understand.
I'm going to reinstate your previous bond where you were previously at home, right?
Mm-hmm.
And then they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right, thank you, Your Honor.
Okay. Don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After
Sure.
consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor, without necessarily violating a confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the Tether agent if that arises.
Response.
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office, so that the court would be apprised of what was happening. But the tether conditions, I believe, ought to remain the same.
Actually, what happened last time was the public defender came up on Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Yates, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told and I made it very clear, we'll bring him in here, because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request is for a tracking tether change.
Stop talking.
This exchange between the judge and counsel is sharp, and it matters. What we're seeing is a dispute over prior objections regarding flexibility in home confinement conditions. The judge believes the prosecution objected more broadly than they now claim. The prosecutor clarifies it was about tracking tether specifics, not hospital transport. Why does this matter? Because clarity in bond conditions is critical. If there's ambiguity about whether a defendant can leave home during a crisis, that ambiguity can trigger another violation. Judge Simpson asserts control firmly. Stop talking. That's not hostility, it's courtroom management. When tensions rise between counsel, the judge must reassert order. This moment also underscores how much these hearings rely on memory and record. Misunderstandings at the bench can shape future rulings. So ask yourself, how much of justice hinges not just on facts, but on communication clarity in real time?
You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
I'm grabbing Mr. Wondering right now, your partner.
Your Honor, I'm very familiar with Mr. Peoples' case that the court wants to proceed.
All right. Ms. Douglas is now here on behalf of the people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make his bond in his new case match the bond with the conditions in his other case so that he can be released, because otherwise he would be held on that. He'll be refitted with a tether on, he'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid. And all prior conditions are reinstated. And then we need a new date. So when do we?
Your Honor, my request.
Well, I got the confident. It's actually going to be October 30th.
Okay.
It's going to be our day. So, all right.
Thank you, Your Honor. May I provide the court with the order to undergo forensic?
There hasn't been enough on this case yet, Mr.
I'm not.
No, go ahead.
May I approach?
Yes.
Thank you.
What is this? No, that's the order on the other case. I'm sorry.
Might be tomorrow, but as soon as you put further on you.
Okay.
Sounds good.
Okay. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're going to do it, right?
Yes, Your Honor.
All right. Okay.
And just like that, Judge Simpson finalizes the decision. The new $100,000 bond is aligned with the prior case conditions, so Samuel can be released. He will be refitted with a GPS tether before release. The $175 payment must be made. All previous conditions remain in place, and competency proceedings move forward on October 30th, 2025. This ruling reflects measured judicial discretion. The court acknowledges the violation but weighs it against mental health concerns and family support. Instead of punitive escalation, the judge opts for structured supervision. The broader implication? Courts increasingly confront the intersection of mental health and compliance. The system must ensure accountability without ignoring underlying crises. Judge Simpson's decision reinforces conditional trust. Comply, cooperate, and follow the rules or face consequences next time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.